That's designed to give you a brand new start. I was just talking to a gentleman a moment ago who said, wait a minute, there's, I don't like the stigma that attaches to Chapter 7 bankruptcy, to any bankruptcy. I'd rather not file for bankruptcy. He's an older gentleman, and I said, yes, because your parents told you that if you make a commitment to pay a debt, you pay that debt. That's what you're supposed to do. You're supposed to own up to it, face the music, pay the debt. And so for you to turn around and say, I'm not going to pay any of my debts, I'm going to wipe it all in bankruptcy, it rubs you wrong. It goes against the grain. You don't feel comfortable with that. But you're entitled to it. It's a fresh new start. It's a federal law. It's been with us for many years. Over, I believe the statistic is about 1.2 million filed last year. People filed. Your neighbors filed. The stigma should not be the thing that stops you from filing bankruptcy, because it may be difficult for you to qualify for a bankruptcy anyway. For a Chapter 7 bankruptcy, you have to be able to show that your income is insufficient to pay all of your living expenses, plus your credit card debt and whatever else is out there. Your car loan, your house payment, perhaps. With this Chapter 7, legally, the process is 180 days. But from a practical standpoint, you bring in all your paperwork to the attorney who does your bankruptcy. The attorney programs this information into a program that that attorney has and sends it off by internet to the United States Bankruptcy Court for the Southern District of California here in San Diego. It gets filed, and within 7 to 10 days, you receive a notice in the mail that you have a hearing. The hearing date is going to be approximately 30 days from the day that the paperwork was filed with the court, electronically filed. You and your attorney should be showing up at this hearing. The hearing is referred to as a 341A meeting of creditors, and you should be showing up there together 15 minutes before the hearing. Why 15 minutes before? Because there's a 4-page document that's called 341A Meeting of Creditors Questionnaire that has to be completed on the day, because you have filed your bankruptcy 30 days earlier. And since those 30 days, they want to know what's happened. Any changes? Anything new? Did you get some new employment, for example, that could change the complex of a Chapter 13 bankruptcy? All right, so that is done. Wow, you really moved right along, Chelsea. We're now on Chapter 13, okay? Before we get off the subject of Chapter 7, from a practical standpoint, your Chapter 7 bankruptcy ends when you get that piece of paper that says discharge of debt. It's two-sided, one sheet of paper you get in the mail as the debtor that says discharge of debt. And it explains that all your debt is wiped out in bankruptcy. You no longer have to pay. Now, are there debts you cannot wipe out in bankruptcy? Yes. What are those debts? What you cannot discharge in bankruptcy, and that's the legal term. Don't get discharge confused with dismissal, by the way. A dismissal of a case means that it got thrown out of court. A discharge means that your debts got wiped out in bankruptcy. A liquidation of debts. You cannot wipe out in bankruptcy Chapter 7 debt that's owed as a result of spousal support or child support. Those will never be wiped out. If you have a fine that was given to you by a governmental entity, that's not going to be wiped out. The taxes that you owe on income taxes, normally that will not be wiped out in bankruptcy unless they have been assessed over 3 years. There's a statute of limitations. And there are other final subtleties with respect to notice and how you can actually get income taxes wiped out in bankruptcy. There are other fine subtleties. There are things that have to be complied with in order to get those taxes wiped out in bankruptcy. What else? Student loans. If you have a student loan, it's federally insured student loan, not going to get wiped out in bankruptcy.